My name is Chris Smythe and I am head of the Criminal Department at Queen Square Chambers. Welcome to our webinar, which will feature a number of speakers dealing with topical issues thrown up by the current pandemic. We will be looking at emergency legislation which has been brought in, how the criminal justice system has had to adapt and what this might mean for the future, the impact in the context of domestic violence, and regulatory liability arising from the lack of or unsuitable PPE. Each talk will last 10 minutes or so, and there are handouts to accompany each topic covered. At the end of the session as a whole, we will provide details of how to obtain these handouts or any further information on these or indeed any other aspect of criminal and regulatory practice. I will introduce first Meabh McGee, a Section 6 pupil, who's going to speak about emergency legislation and practice directions that have been brought in as a result of the pandemic. Meabh, over to you.
Thank you. Today I'll be focusing on the Coronavirus Act and what changes this has made to existing legislation and the practice directions. I will first be giving an overview of the most important temporary amendments that have been made and how this has expanded the use of live links in criminal proceedings and hearings. I will also briefly touch on relevant sentencing considerations that may be taken into account during this time. Much of the content I will speak about regarding the Coronavirus Act is contained in a handout that will be made available afterwards. Turning first to the effect of Schedule 23 from the Coronavirus Act and the amendments it has made to Section 51 of the Criminal Justice Act and Part 18 of the Practice Directions. Normally under Section 51, a witness, other than the defendant, may be able to give evidence through a live link in certain criminal proceedings. Live link was defined in Section 56 as a live television link or other arrangement by which a witness is able to see and hear a person. The 2020 Act has extended the definition of live link to include live visual link and a live audio link. It is worth noting at this point that the use of a live audio link is the exception rather than the norm during these times. When live audio links can and cannot be used will be dealt with a little later on. Section 51 has been extended to enable any person to take part in eligible criminal proceedings. This now enables a witness, defendant, and judge to take part of a live link. However, the amendment does not apply to any jury member. Before the Coronavirus Act, live links could only be used to give evidence. Now, people can take part, meaning a person is able to give evidence, but are also able to attend the proceedings when not giving evidence. Prior to the 2020 Act, there were a list of 7 types of criminal proceedings that live links may be used in. Not only has the 7 already named widened in scope, but additional proceedings have been included in this list. It now covers any proceedings that are preliminary or incidental to a criminal appeal, to the Crown Court or Court of Appeal, instead of just the appeal itself, and any trial in the Crown Court instead of just a trial on indictment. I don't intend to read this new list out, but you will be able to see this in the handout of what amendments have been made. As previously mentioned, audio proceedings are the exception. The Coronavirus Act has introduced Schedule 3A to the Criminal Justice Act. It sets out what proceedings may be conducted wholly as audio proceedings and/or wholly as video proceedings. However, all of the named proceedings that can take place over audio live link are subject to a number of exceptions, namely, the defendant may not give evidence via audio link during any of the named proceedings, and any other person may not give evidence by audio link unless there are no suitable arrangements for the person to give evidence by video link and the parties agree. Before all this, and before a live link direction can be made, the court must be satisfied that it is in the interests of justice, and parties to the proceedings have to be able to give the opportunity to make representations. If the defendant is under the age of 18, then the relevant youth offending team has to be given that chance to make such representations. There are a few other important points to note. The amendments now mean that a person who takes part in proceedings over live link are treated as being present in court and complying with any requirement to attend court or surrender to the custody of the court. The court still has a little flexibility under the amendments. Live link directions may be applied to some or all participants. They may apply to only some aspects of a person's participation in proceedings, like the giving of evidence, and they may apply to persons outside of England and Wales. In the Magistrates' Court, a single justice is able to give live link directions. Schedule 24 expands the use of live links to live video and audio links and to all participants during certain preliminary, sentence and enforcement hearings. Much of what has already been said applies to these type of hearings. I will now focus on how the amendments apply to specific circumstances. As previously mentioned, defendants are not able to give evidence by live audio link. In certain proceedings, the defendant is unable to take part at all by live audio link, including contested bail applications, when the court is minded to deal with someone for contempt of court, and sentencing. In each of the above, a person, other than the defendant, may not take part by live audio link unless they do so only to give evidence, there are no suitable arrangements for that person to give evidence by live video link, and the parties agree. The court is unable to do certain things if a person takes part by live audio link unless they do so for the purpose of giving evidence. This includes refusing or revoking the defendant's bail if the defendant objects, taking a guilty plea, or dealing with someone for contempt of court. Under Schedule 25 of the Coronavirus Act, the court has the ability, when proceedings are to be conducted wholly over live link, to direct that the proceedings are to be broadcast so members of the public can see and hear, and they may also direct a recording of the proceedings to be made so the court can keep an audio-visual record. The court can only do this when all persons taking part in the proceedings do so through a live video link or through a live audio link. There is no provision where it is a mix and match scenario. A common theme that can be seen throughout these amendments is the focus and emphasis placed on using a live video link as much as possible. It perhaps recognises the importance of being able to see someone's face rather than just hear their voice. Live audio links are very much the exception throughout all of this. It is an option, considering the restrictions on movement in the UK at the moment and the fact a person may be unable to access a live video link. However, as far as possible, people are encouraged to use a live video link. Turning now to sentencing at this time. The Lord Chief Justice, in a judgment yet to be made available, outlines some important and relevant considerations to be taken into account when sentencing. In accordance with established sentencing principles, the court will take into account the likely impact of a custodial sentence upon an offender as well as others. Therefore, it is relevant that the impact of a custodial sentence is likely to be heavier during the current state of emergency. Those in custody are confined to their cells for much longer periods and are unable to receive visits. It is perhaps also of relevance the anxiety both the offender and their families might have about the risk of coronavirus in custody. Applying ordinary principles, where a court is satisfied that a custodial sentence must be imposed, the likely impact of the sentence continues to be relevant to the necessary length of the sentence and whether it can be suspended. The considerations I have spoken about and the impact of coronavirus on custodial sentences may be a factor in reducing the overall sentence to be imposed or suspending it. The question is now, when will these amendments and changes to criminal procedure no longer be used? The Coronavirus Act is time limited for 2 years, unless there is a formal parliamentary approval for it to continue beyond that point. Therefore, for the time being, it seems most criminal proceedings and hearings will be conducted as far as they can be via live link. What this means for jury trials is yet to be seen. Thank you.
Thank you, Meabh. It just goes to show what a sea change we have undergone in the way we practice. The authority which you refer to as the case of Manning is unreported at the moment. It was decided on the 30th of April and is obviously a very important decision in the current regime of sentencing. Our next speaker is Ieuan Callaghan, and he is going to be speaking about penalties which can be imposed for breaching the new rules that we have in the current pandemic. Ieuan is also a Second Six pupil, and over to you, Ieuan.
So today I'm going to talk about some of the new offences that have been created under the coronavirus lockdown. So what are the new coronavirus offences? Well, there's two sources. The first are those that have been created under the Coronavirus Act 2020, and the second are those that have been created under the Health Protection Regulations under the Public Health Act 1984. I'm going to focus on the regulations for the purpose of this talk, but for reasons that will become clear in just a moment, I'm just going to turn to the Coronavirus Act offences. Now, they've been created in 3 separate areas. So Schedule 20 creates powers and offences in relation to the suspension of port operations. Schedule 21 deals with potentially infectious persons. And Schedule 22 gives power to Secretary of State and Welsh ministers to prohibit or restrict events, gatherings, and to close or restrict access to premises. Now, all of those schedules have offences in their own rights. However, it is the health protection regulations that are concerned with the general rules that we've come to know that characterise the coronavirus lockdown, and it gives powers to the police and other relevant persons to enforce those rules. And it's for those reasons I'm going to focus on the regulations. Now, the full titles of the regulations currently in force in England are the Health Protection Coronavirus Restrictions England Regulations 2020, number 350. They came into force on the 26th of March 2020, and they've been amended once already on the 22nd of April. So what are these rules that I refer to that characterise the lockdown? Well, we all know them, we live them every day. The first, of course, contained in Regulation 4 was the closure of pubs, restaurants, cafes and bars and other businesses. Regulation 5 contains the restrictions on businesses that are permitted to remain open. Regulation 6 restricts leaving home without reasonable excuse. And Regulation 7 forbids gatherings of more than 2 people in a public place. Regulation 8 is concerned with enforcement, and it gives powers to enforce the above rules to relevant person. In most cases, that relevant person will be a police constable, but it also includes a police community support officer, as well as another person designated by the local authority or Secretary of State. Now, compliance with the regulations can be enforced by the issuing of a prohibition notice in respect of premises, can be enforced by a direction or a removal of a person to their home by reasonable force if necessary and proportionate. It can also be enforced by the directing of the dispersal of gatherings of 3 or more people, as long as they're not all from the same household. The use of all these powers must be necessary and proportionate. So what are the actual criminal offences that have been created under the regulations? Well, there's 3. The first is the contravention of a requirement in Regulation 4, 5, 6, 7 or 8 without reasonable excuse. So an example of that could be a pub remaining open when it shouldn't, or it could be a gathering of 2 households in a public place. Secondly, obstruction without reasonable excuse of a person carrying out a function under the regulations. Now, an example of that could be a situation where a constable is attempting to remove someone back to where they live, and that person is obstructing them from doing that. Thirdly, contravention of a prohibition notice or direction or reasonable instruction given to a person under Regulation 8, again, without reasonable excuse. And this applies to a situation where a person has been given a direction or a premises has been given a prohibition notice, and that person has continued to persist in doing what they were doing that contravened the regulations. Those are the offences, and what are the penalties that flow from those? Well, all of them are summary-only offences, punishable upon conviction in the magistrate's court by a fine. However, according to the discretion of the relevant person, the police constable, most likely, they may offer a fixed penalty notice to a person over the age of 18, or 18 and over from the 22nd of April. The fixed penalty notice sum for a first offence is £60. However, that can be reduced to £30 if paid in 14 days. For a second offence, the discount doesn't apply and is in fact doubled to £120. And for every following subsequent offence is doubled again to a maximum of £960. So that's a broad overview of the coronavirus offences with a focus on the offences under the regulations in particular. And I'd like to end just with some thoughts on how one might challenge a charge brought under that legislation. The first stage is to ask, well, what am I charged with? Is it under the Coronavirus Act or is it under the regulations? If it's under the Act, which schedule of the Act? You'll have likely seen examples in the news of where people have been incorrectly charged, perhaps under Schedule 21 of the Coronavirus Act, which applies only to potentially infectious persons. You'll have seen examples of people being wrongly charged with that and their conviction having to be quashed. So making sure that the right charge has been brought is in fact critical, as the police have struggled with charging correctly. In the same vein, it's important to check that the right charge is brought under the correct national provision. Schedules 21 and 22 of the Act both have a separate part for England, Wales, Northern Ireland and Scotland. And the same is that each of the UK nations has their own version of the regulations. So it's important to check that you're being charged on the correct national provisions, and you'll likely have seen examples of that occurring in the national news as well. One example is that in Wales, you can in fact be permitted to leave for exercise twice in a day when you have a particular health condition or disability, whereas the English regulations make no such allowance. And finally, jumping on from the end of that thought, was there in fact a reasonable excuse? It's a defence to all three of the regulations offences and to some of the Coronavirus Act offences, a reasonable excuse. We're all familiar with some of the reasonable excuses given, and the lists provided in the regulations are non-exhaustive. So what constitutes a reasonable excuse will in fact depend on the particular facts and circumstances of the case itself. The College of Policing have produced some examples of what may or may not constitute a reasonable excuse in the context of leaving your home. And I'll provide that in the handout that Colleen can tell you how to obtain at the end of the talk. But it's important to recognise that police have not had an excellent track record in charging under the new legislation, to the point that the CPS have now announced that they will be reviewing every charge brought under the coronavirus legislation. So it's important to keep this under review. That's about everything I wanted to cover. It's been a broad overview of the offences under the coronavirus legislation, and I end with the caveat that, like with everything else, everything is changing day by day, so it's important to keep it under review. Thank you for listening.
Yeah, and thank you. So far, we've heard about legislation which regulates practice in the courts. We've just heard about offences which the courts are applying. And now we're going to hear from Charlotte Evans, a Second 6 pupil, who's going to talk about the practical way in which the courts are operating and what this might hold for us in the future. Charlotte.
Thank you, Chris. I'm going to be talking about the practicalities of attending remote hearings and what the future might hold for jury trials as lockdown continues. What is currently working? Administrative, sentencing and bail hearings are able to run without the need for advocates, defendants or judges to physically attend the courtroom. And when not laced with technological difficulties, they do allow a court list to run almost as normal. Defendants can be arraigned and have pleas taken without physically attending court, and decisions are being made to allow some cases to move along despite lockdown. The video call facility, in comparison to audio-only hearings, allow for almost everyone physically present to be able to see each other. How are they not working? Trials, of course, are still unable to take place, and there are technical issues with being able to see and hear all participants due to a mix of people sometimes present in the courtroom, sometimes over video link, and sometimes appearing only via audio link. Defendants that are currently in prison are not able to join the main video link and be heard clearly. Instead, they are being dialed in through the courtroom video link facility, and a laptop connected to the video call is placed in front of the screen. Well, this is causing issues across the board with their sound quality, with echoes, and really with the defendant being able to participate at all in the proceedings. Sometimes the only way to reduce the echo in the courtroom is to mute the defendant's video link, which means the defendant cannot contribute at all to the hearing. Defendants who are on bail need access to equipment that can video call in order to plead, so some have to attend in person to their local court in order to use the linking facilities. Those issues are all when the technology has actually connected successfully. Of course, significant delays are still caused when it does not go smoothly, and there is a significant lack of communication when hearings are delayed that often leave advocates and parties on the end of a phone call not knowing when it'll be answered. So how can we mitigate what isn't working? His Honour Judge Blair QC circulated guidance on Tuesday, which included requiring advocates instructed to defend to have at least a telephone conference with their defendant, if on bail, no later than the day before the hearing. He also set out that if a conference is required with a defendant in prison on the day of the hearing, the advocate must contact the court no later than midday the day before the hearing in order to facilitate this. Further, if pleas are to be entered, the court should be notified in advance so that a stand-down report can be arranged if possible. Clearly, communication with clients and with opponents before the hearing is particularly important now, as it is not guaranteed that there will be time to discuss matters before the judge joins the link. It is also notable that some courts have members of the press on the video call, so discussions even before a judge enters may not be private. To alleviate the more practical issues, anyone conducting a hearing can have their microphone muted when not talking, as it reduces the risk of the speaker's audio cutting out due to background noise being picked up. Can then remember to unmute their microphone when they speak. Using headphones can help with a microphone if at all possible. iPhone headphones work well as they have a built-in microphone, and this can increase the quality of the audio. Often the courtroom microphone will produce an echo, which can make it very difficult to speak coherently. It can be worth suggesting that the court microphone is also muted while others on the video link are speaking, as that can remove the echo. I'll move on to look at what the future might look like. The topic that has appeared most frequently in the media and amongst legal professionals is whether jury trials could be conducted safely during the COVID-19 lockdown. The first suggestion is dip-lock courts. Jury trials could become optional for a period, and defendants could opt for a trial where the circuit judge sits as a tribunal of law and fact. Could this work? The need for the defendant to consent would mean that he would still have a right to be tried by a jury of his peers, but could elect for a more expedient trial. It would reduce but not eliminate the COVID-19 risk. Judges would have to give detailed reasons for findings of guilt, which could be examined on appeal. But the potential issues. would it be considered second-class justice, with the defendants and complainants feeling cheated depending on the result? And does the option of expedient trials create a risk to jury trials in the future? A potential concern is that the attractiveness of a much more cost-effective, quicker trial could prompt the government into pushing to reduce or even abolish jury trials in their entirety, although the same has not happened in Australia, which introduced this option. Practically, would a lawyer ever advise a defendant to do this? Potentially not, given the difference in conviction rate between, for example, magistrates' courts and jury trials. A suggestion where it could work well could be a case where the defence believe that the prosecution will fail to prove an element of the offence. It could be lower risk to have a legal expert examining the evidence rather than an unpredictable jury. But would it serve its purpose? It may not effectively alleviate the backlog of jury trials if very few defendants would actually elect. Another option is remote jury trials. The Law Society Gazette reported on the 20th of April that the campaign group Justice had run an experimental, fully remote mock jury trial to test if it could be a fair alternative, which they said worked well. Could it work in practice? Well, it could be conducted safely, removing all risk of COVID transmission. Everyone could be heard and seen clearly, and jurors would be comfortable not having to sit very close to each other. It ensures dignity of the defendant if on bail, without the defendant in the physical dock. It could alleviate any prejudices that jurors may come in with, and might make the process less intimidating for vulnerable defendants or witnesses. However, the negatives. Would witnesses and jurors feel a lack of solemnity? Would they be more likely to give unreliable evidence, or jurors less able to concentrate when there's a rift between them and the trial, with all of the unpredictability of their home environment that we're all now knowing so well? If the defendant is in prison, would the same issues arise with being able to adequately participate in their trial? If so, would defendants be able to elect to wait until an in-person trial could be held? The technological issues. If a juror drops out at any point, could this be the subject of an appeal? Would judges be able to ensure privacy? There is no surety that jurors would keep their discussions confidential. A lot of trust would have to be put in them, and how could their responsibilities be enforced? And lastly, the point of equality. Would all jurors have the technology and broadband connection to be able to participate? And if they don't, would it be provided? Or would jurors be chosen based on whether they could be able to participate easily? Would this create a social imbalance in the jury construction? The last viable option is socially distant trials. The Lord Chief Justice of England and Wales told Radio 4 last week that it might be necessary to look at such radical measures. For example, reducing the number of jurors from 12 to 7, as happened during the Second World War. Is that fair? The current minimum number is, of course, 9 if there are issues with current impaneled jurors, but only a unanimous verdict would result in a conviction. Would defendants feel they had justice if they were convicted by only 7 of their peers? A different suggestion by the Lord Chief Justice was that cases could be heard by a full jury in larger buildings such as university lecture halls. This could work in that lecture halls are currently not being used. They have facilities for amplifying and recording those speaking, and are big enough that social distancing could be enforced. There would also be plenty of space for the public and the press to attend, and universities would have seminar rooms appropriate for jury discussions. The issues, the ones easily noted, that the recording facilities may not have been built for recording more than one speaker across different areas of the theatre, and the security, as lecture theatres may not now be built to house secure hearings such as jury trials. Is the risk of COVID eliminated? There will always be shared spaces, corridors, restrooms, and passing each other to get to their seats. If one juror reported symptoms, all participating in the trial would have to self-isolate for 14 days, which would essentially prevent the trial from being heard. And the last issue is who would attend. Jurors will be taking a personal risk to attend court, as they may have to use public transport, and there will always be some infection risk when attending a public building. Would those falling into the vulnerable person category be excused, or would it be optional? And who would then choose to take such a risk? What does that mean for the makeup of the jury? The same issues apply to the suggestion that trials could take place with a full jury across multiple courts in the Crown Court building. The issues as to security and appropriateness would of course be eliminated, but there will never be a zero-risk way of facilitating social distancing. Currently, there is a jury trials working group that is working with Public Health England and Wales to assess whether any court spaces could be appropriate for socially distant trials. And a part-heard trial with no witnesses was listed in the Old Bailey this week, which started Monday. It will be interesting to see how social distancing measures were implemented and how successful they were. The final option is the thought I will leave you with, which is this: is it viable to wait until this all blows over? What are the possible consequences of not having any jury trials until lockdown ends? Social distancing measures are likely to be in place long after the lockdown ends, potentially until the end of the year. So is it viable to simply wait until trials can be conducted as they were? Probably not. We are likely to see change in the very near future. Thank you for listening.
Thank you, Charlotte. Currently, virtually all hearings are being covered via Skype, and it is important to remember that they remain a public hearing, and you can perhaps forget that as an advocate appearing in court from your study or wherever you have at home. And it's worth bearing in mind that press can actually attend, and you must treat these hearings with the same degree of seriousness and solemnity as you would as if you were appearing in court. Now, the lockdown has brought families, kept families together within the home, and this is something that Kat Flint, barrister, is going to be talking about in the context of domestic violence. Kat.
Chris, according to the Counting Dead Women website run by the domestic abuse campaigner Karen Ngala Smith, between the 23rd of March and the 12th of April of this year, there were 16 women and children killed in suspected domestic violence incidents. This compares to a 10-year average of 5 for the same period. Now, like with all coronavirus-related statistics, we probably won't be aware and won't know the true picture until after the crisis has passed. But an apparent threefold increase in domestic homicides is alarming and is, of course, only the tip of the iceberg when it comes to all domestic violence incidents. Figures available from other sources, plus anecdotal evidence from criminal defence firms, all seem to support that there has been a significant increase in domestic violence during the lockdown. Refuge, the UK's largest domestic abuse charity, reported a 700% increase in calls to its helpline in a single day during the lockdown, whilst the Metropolitan Police have reported a 24% increase in domestic violence charges and cautions between the 9th of March and the 19th of April, compared to the same period last year. Now, in many ways, this is depressingly predictable. The pressures that lockdown has brought to many families, the financial stress, anxiety for many in terms of their future employment, and perhaps the greater use of alcohol as a coping mechanism, all contribute to things that could further exacerbate what may already be a very volatile situation. That, coupled with the confusion about the extent of the lockdown restrictions, perhaps being exploited by controlling partners and used to further isolate their victims, all further contributes to the increasing prevalence of domestic abuse under lockdown. And if the police and if some district judges get confused about the coronavirus laws, what hope does a victim of domestic abuse living with her abuser have in these circumstances to understand it? There's also been some anecdotal reports of an increase in stalking and harassment type offending. Again, it doesn't take too much imagination to see how someone's stuck at home without their usual distractions, maybe stuck at home on their own, and how they might start to ruminate and obsess to an extent that they begin to engage in that type of offending, perhaps against their current partners who they live apart from, or perhaps with ex-partners. So far, so inevitable. But what does this all mean in terms of prosecutions and the challenges in the current circumstances for both prosecutors and defendants? Well, the first is time limits, and I don't mean custody time limits as such, I mean the charging time limits. Nicole Jacobs, the Domestic Abuse Commissioner for England and Wales, in evidence given to the Home Affairs Select Committee last month, raised that there are going to be people experiencing domestic abuse at the moment, but are unable to call the police because it's simply not safe for them to do so, and may not be so until the lockdown is lifted. Now, we all know that the vast majority of domestic violence offending is summary only. It's common assault, harassment, and criminal damage, and therefore is subject to a 6-month charging limit. It was suggested in that Home Affairs Select Committee that the 6-month limit be relaxed in these circumstances so that these particularly vulnerable victims don't fall through the cracks. I mean, whether this will come to fruition remains to be seen, but it is and remains a possibility. Another way this could be tackled, specifically in relation to assault, is where there is some level of injury, but relatively minor, and so would ordinarily attract a charge of assault by beating, instead being charged as ABH. The CPS charging standard already allows for ABH to be charged where the injury is less serious, but there are other aggravating features present, one being the circumstances in which the assault took place. Now, it's arguable that a domestic assault taking place in the circumstances of a national lockdown and a national emergency is more serious, and particularly when the complainant is vulnerable. Another challenge in respect of a successful prosecution is continued victim engagement. Now, we all know that one of the main hindrances in successfully prosecuting domestic abuse is the complainant retracting. And the longer from incident to trial, the greater risk of retraction. This is why domestic abuse cases and domestic abuse trials are prioritised. Now, there are inevitably going to be delays under the current circumstances in getting cases to trial. And at this time, we have no idea when normal service will resume. There is then a real danger that those delays will have a disproportionately negative impact on domestic violence conviction rates at a time when domestic violence offending is at an all-time high. In an attempt to counter this, we may well see a greater number of victimless prosecutions. Now, in terms of defendants and how these circumstances are affecting defendants in domestic violence cases, well, anecdotally again, an issue that has been arising is one of bail. Bail conditions preventing a defendant from contacting the complainant or living in the family home are commonplace in DV cases. Now, in ordinary circumstances, defendants may be able to stay with parents or family or perhaps friends. But this may very well not be possible under the current lockdown. Elderly parents may be in a vulnerable group, and friends who may already be finding restrictions difficult probably don't want an extra body on their sofa. And of course, hotels, bed and breakfasts, and Airbnb type accommodation is simply not available at the moment. So hopefully, as restrictions are eased, this may become less of a problem. Whether, though, in the meantime, this is translating into a greater use of remand is unknown, but it would certainly seem to run counter to my next point, which is sentencing. And of course, Meabh has already touched on this in her talk that she just gave. But at the moment, it seems that courts are very much being encouraged to avoid custodial sentences wherever possible. The case that Meabh referred to, the Crown against Manning, stated that the current conditions in prisons represent a factor which can properly be taken into account in deciding whether to suspend a sentence. And it went on to say that judges and magistrates can and should keep in mind that the impact of a custodial sentence is likely to be heavier during the current emergency than it would otherwise be. In addition to that guidance, the courts are also taking a much more flexible and generous approach to credit for guilty pleas at the moment. So to finish up, all the emerging evidence suggests that there has been an explosion of domestic violence under the current lockdown. However, with the usual obstacles to prosecuting domestic violence cases all greatly aggravated under lockdown, whether the greater numbers of incidents will eventually be reflected in a greater number of convictions remains to be seen. Thank you.
Thank you, Kat. Now, a slight change of tact with our last speaker. Jack Duffy, barrister, with his regulatory hat on, is going to talk about liability arising from no PPE or unsuitable PPE. Jack.
Thank you, Chris. The remit of my talk will concentrate on corporate criminal liability following deaths at work caused by COVID-19. This will involve an analysis of the legal definition of PPE and the law in relation to corporate manslaughter. I'll also be touching upon some of the governmental guidance that's been provided about PPE so far, and you'll find all that source material in a separate leaflet that Colleen will give further information on at the end of the talk. Unfortunately, due to time restraints, I won't be touching upon the regulations for self-employed, nor on personal liability to gross negligence manslaughter. Both of those topics are worthy of a webinar in themselves. But for now, I'll be focusing upon corporate manslaughter and liability for employers. To begin with then, I'll start by defining PPE. It stands for personal protective equipment, and when spoken about, it might evoke imagery of Hurt Locker EOD suits or Walter White hazmat suits, but it's defined in the regulations as much wider than that, as all equipment is intended to be worn by a person at work, which protects them against one or more risks to their health and safety, including goggles, gloves, basic safety equipment. Currently, the need for PPE is unprecedented. The UK has experienced over 30,000 deaths and rising, and according to the Office of National Statistics, there have been just under 2,500 deaths under the age of 65. According to some reports, there have been 119 identified deaths of NHS workers from COVID-19. And what this means is that there are many people who have likely been exposed to COVID-19 at work, and many people who may have died from that as a result. So the question is, will the employer, as a corporation, be liable if they hadn't done more to protect their employee? The offence of corporate manslaughter is defined in the 2007 Act, and it states that the organisation is guilty of an offence if in the way it manages or organises activities causes a person's death and amounts to a gross breach of a relevant duty of care. So once the employer is considered a qualifying organisation within the Act, one of the first questions to ask is, what duties do they owe the employee? There are general duties to keep your employee safe. However, there are specific duties in relation to PPE, and these are encapsulated in regulations in 1992. Regulation 4 there states that every employer shall ensure that suitable PPE will be provided for their employees who may be exposed to a risk to their health or safety while at work. The only proviso of that being, PPE is not necessary if that risk can be adequately controlled by other means which are equally or more effective. Examples clearly being working from home rather than PPE at work, or potentially the use of splash barriers, or perhaps social distancing, which might be just as effective. But an important aspect of those regulations is that the provision of PPE is necessary, but it also has to be suitable. And subsection 3 of Regulation 4 highlights a number of meanings to this. A few examples are that the PPE has to be appropriate for the risks involved, has to take into account the persons wearing it, and has to be effective to prevent or adequately control the risks involved. On the face of that, then, it appears that there could be a legal case for prosecuting employers who have not provided their employee with PPE or provided them with unsuitable PPE, and that employee has died as a consequence. Importantly, this extends to all employees, not just NHS staff and care workers, but also shop attendants or other workers not in lockdown and exposed to COVID-19. However, to be found guilty of the offence, the breach of that duty has to be gross. And that's defined in the 2007 Act at Section 4B, and it states that gross means if it falls below what can reasonably be expected of the organisation in the circumstances. Looking at that then, clearly here the circumstances are unusual, with significant pressures on employers. But more than that, when looking at what is expected, one has to look at the current guidance. And this is specifically catered for in Section 8.3b of the 2007 Act, where it states that the jury may look at health and safety guidance to determine guilt. The government has published a number of documents on the use of PPE. In that guidance, they've split employers into two categories: those working in health and social care sectors and those who aren't. There are exceptions to this, with specific guidance for employees working in the police force or cleaning in non-healthcare settings, but largely they fall into those two broad categories. For health and social care sectors, the guidance is in relation to what is appropriate PPE in the circumstances. And this relates to sessional use of PPE in certain circumstances, for example, during a singular ward round when you see a number of different patients. But in other circumstances, such as aerosol generating procedures, where more risks are involved, more precautions must be taken. For all other workers and sectors, the guidance published on the 10th of April states that based on current evidence, there's very little scientific evidence of widespread benefit from PPE. Instead, practicing good hand hygiene and social distancing are key to minimizing the risk of infection. It then goes on to state the most effective ways for employers to protect their employee is through social distancing and splash barriers, use for signs in the workplace, and regular breaks. The result is that even if that guidance is wrong, it is likely that an organization is only expected to provide a standard as high as stipulated in guidance. But the guidance isn't law, and it does not cater for every situation. Therefore, employers should be wary of providing protection as appropriate for their employee, which takes into account shifting risks and the need to adapt. What is clear, though, is that if that guidance isn't followed and someone dies, it may be then that the employer becomes criminally liable. There are two caveats to that. Firstly, there are likely to be difficulties with proving causation. The question is, did the breach cause the death? Normal criminal causation applies, namely that it need not be the sole cause, or even the main cause, as long as it was an operating cause that had more than a minimal contribution to the death. And this is complicated enough when you ask, what was the scientific cause of death? In certain circumstances, the deceased may have had underlying medical conditions, which could have been the ultimate reason for why they died. In those circumstances, asking whether COVID-19 had more than a minimal contribution to death is a sensible and effective test. However, it may be more difficult to ask what caused the deceased to actually contract COVID-19 in the first place. In certain circumstances, it may not be possible to prove that the omission of PPE, provision of unsuitable PPE, was how the deceased caught the disease. This is because, given the prevalence of COVID-19, the employee could have caught it at home, on their way to and from work, or perhaps doing their daily exercise. In civil law, this issue has been solved somewhat when it comes to the special rules that apply to industrial diseases, such as mesothelioma, following exposure to asbestos dust. And there, the test is whether or not the breach of the duty of care led to a material increase in the risk of catching the disease. But no such special rules are applicable to corporate manslaughter. Therefore, it may be very difficult to prove that someone caught the disease at the time that the employer was breaching their duties. The second caveat is that guidance on how to use PPE is useless if there is no access to PPE. And one of the major issues we currently face is that there is a severe shortage of appropriate equipment. There's also been guidance provided about this as well. And that essentially states that during these exceptional times, the Health and Safety Executive approves the sessional and reuse of PPE, contrary to health and safety guidance, as long as it is safe to do so. Dame Donna Kinnair, the Chief Executive and General Secretary of the Royal College of Nurses, has called this guidance unacceptable. She says it's unacceptable that any healthcare setting in the UK does not provide PPE as required by health and safety guidance. And this should also be considered in light of the guidance provided by the Chief Coroner, His Honour Judge Lucraft, on the 28th of April 2020. And he states that coroner's inquests into deaths should not look at whether adequate general policies and arrangements were in place for provision of PPE to healthcare workers. And this has been controversial, but it merely restates the legal position that the coroner's court is not the place to investigate public policy. What this means then is that, in my opinion, looking at the information that is available at this time, any prosecution for corporate manslaughter in these circumstances are fraught with difficulties, making a successful prosecution very unlikely. Governmental guidance seems to be making allowances in the employer's favour, both the provision of PPE and the consequences of shortages. But guidance is constantly shifting, and employers must keep abreast of the information provided for them as soon as it becomes available, as that is the metric that they'll be assessed upon. The biggest risk of prosecution arises from the employer's non-compliance with the governmental guidance at the time of the breach. However, it seems that even when that happens, a successful prosecution may still be unlikely without an inherent shift in the law of causation in relation to corporate manslaughter. And that shift must be towards something more akin to the civil rules on industrial diseases. But in any case, it is likely that questions will be asked about the way employers have dealt with protecting their employees during this crisis. And the severity of the current situation cannot be a blanket defense to all negligence. Deaths must be analysed on a case-by-case basis, with any prosecuting authority applying a common sense approach, taking into account the exceptional times and extraordinary pressures on employers. There have been concerns raised in the past, most notably with a review by Leslie Hamilton in 2019 that pointed towards issues in relation to the quality of expert evidence and the quality of the processes leading up to criminal investigations for prosecution for manslaughter. However, hopefully these issues have been ironed out, and any litigation will be based on proper scientific evidence with a realistic view of the current circumstances. Thank you for listening. You may be pleased to know that's the end of my talk, and then I'll pass you back to Chris.
Thank you, Jack. That completes our presentation, but I would now like to pass over to colleen-i, our Senior Criminal and Regulatory Clerk, who will tell you how to get in touch for handouts or any other information which may be of assistance.
Thank you for taking the time to view our webinar. We hope that you found it informative. The handout that was referred to within is available if you drop me a line at crime@qsc.law. I'd be happy to provide that to you, and any other information in relation to those that you've heard from today or the team beyond. This information is also available on our website, www.qsc.law. Alternatively, if you'd like to give me a call to discuss anything that you've heard today or discuss any of the members of the team, I am available on 0117 9211 966. Many thanks. Hope to hear from you soon.